counsel for accused number 1 is still arguing the closing argument.
During court session, you will still vote.
Thank you. Yes, I'm also in possession of the request for further particulars. I have gotten a copy from Ms. Cullett's representing accused number 2. I'm also requesting leave to hand same up before the arguments proceed. Thank you.
Thank you. Worship, according to my notes, I was taking worship through my heads of argument on the 9th of December, and we're completed paragraph 59 on page 38. And I made a note of where I was when we stopped.
I just want to endorse that there will be within a minute.
As worship.
And just for the record to state that the court was in session by 9, the state, the defense and the accused was present. Our court machine was working. When the media set up, something happened to the machine which caused us all to move to a new court, hence the delay in proceeding this morning.
Your worship, even in defense of your worship, the media were entitled to come in. Your worship had made it clear they had authority from before. But they waited, there was no need to wait. So,
I think it's just the plugging in that caused the problem with the court machine that caused the delay now.
There was a wire that's fine. That's good.
I'll be with you now. Sorry, for the record, Advocate Matthews, the defense also ready to proceed. Said for the record, you are also still ready to proceed today? I have to acknowledge you at least. Mm-hmm. Just to hear from everyone present and just to note that I now indeed have, thank you to Advocate Collins, the request for further particulars which I have been requesting from the beginning of the matter. I will now attach it to form part of the record. A request that I now spend time and acknowledge all the media houses present. Okay. Zianda Zweni from the Daily Dispatch, Intle Mboyana, Daily Dispatch, Sipa Kema, Newsroom Africa, Siyabonga Ngayana, Newsroom Africa, Coralie Dorfling, Network 24 or Media 24, Ronald Masinda, ENCA. The handwriting here is very small. I see is a Tanto Lebayana from the EFF. The handwriting is very small. Abungile Yankees, SABC. Atobile Vena, SABC. Is that everyone? Thank you. Thank you, Advocate Otis. You said paragraph 59.
You completed your page 38.
Have you got it? You should have went to page 38.
Yes, yes.
I still
I've got
recall...
confirmation from my colleagues as well.
Okay. I seem to recall we were still at the point where you were saying the state has become, I don't know, camera happy, and then we call time. But nonetheless, let us proceed.
Yes, Worship, please.
Page 38.
I dealt with the argument on the merits, and this is where we turn to the law, Your Worship. And the heading is the onus after the defence have closed their cases. And there's reference to the decision of State versus Ndlovu, a decision of the Supreme Court of Appeals in 2002, and a quote from paragraph 18, where we said, third, an accused cannot be ambushed by the late or unheralded admission of hearsay evidence. The trial court must be asked clearly and timelessly to consider and rule on its admissibility. This cannot be done for the first time at the end of the trial, nor in argument, still less in the court's judgment, nor on appeal. The prosecution, before closing its case, must clearly signal its intention to invoke the provisions of the Act, which is then defined as Law of Evidence Amendment Act 45 of 1988. Before the state closes its case, the trial judge must rule on admissibility so that the accused can appreciate the full evidentiary ambit he or she faces. 61. After the accused have closed their respective case, the prosecutor bears the onus of having to prove the guilt of the accused beyond reasonable doubt. This concept has been the subject of numerous judgments, and in particular the following. And then we explain the evolution of how the onus was applied, Worship, going back to 1982, the decision of State versus Kubeka, where the Honourable Mr. Acting Justice Stomwitz held. Evidence ought not to be looked at piecemeal and in isolation. All of it should be analysed and weighed together to determine whether the state has proved its case beyond a reasonable doubt. They reference to numerous cases for that principle, and then he held, in the result I'm left with the uneasy feeling that I have not been apprised of all the relevant and material facts, and that what really happened might be something different from that which was deposed to. The evidence is therefore insufficient to disturb the presumption of innocence. The accused is found not guilty and is discharged. Thereafter, in 1986, Your Worship, in Venda, there was a decision of also another acting justice from the Spain, State versus Munyai, where he held as follows. In other words, even if the state case stood as a completely acceptable and unshaken edifice, a court must investigate the defence case with the view of discerning whether it is demonstrably false or inherently so improbable as to be rejected as false. There is no room for balancing the two versions, i.e. the state case as against the accused case, to act on preponderances. This is clear from the next case to which Mr. Bursey refers, namely State versus Singh Supra, in which their lordships held that in criminal cases where there is a conflict between the evidence of the state witnesses and that of the accused, it would be quite impermissible to approach the case on the basis that because the court is satisfied as to the reliability of the state witnesses, it therefore must reject the accused's evidence. It is held that the proper approach in such a case is for a court to apply its mind not only to the merits and the demerits of the state and the defence witnesses, but also to the probabilities of the case. It is only after applying its mind to such probabilities that the court would be justified in reaching a conclusion as to whether the guilt of the accused had been established beyond all reasonable doubt. Then, as I said, Your Worship, there was a development in 1999 in State versus Van der Meyden, where Mr. Justice Nugent disagreed with that approach and held that the onus of proof in a criminal case is discharged by the state if the evidence establishes the guilt of the accused beyond reasonable doubt. The corollary is that he is entitled to be acquitted if it is reasonably possible that he might be innocent. See, for example, Ricks versus Difford, especially at 373-383. These are not separate and independent tests, but the expression of the same test when viewed from opposite perspectives. In order to convict, the evidence must establish the guilt of the accused beyond reasonable doubt, which will be so only if there is at the same time no reasonable possibility that an innocent explanation which has been put forward might be true. The two are inseparable, each being the logical corollary of the other. The process of reasoning which is appropriate to the application of that test in any particular case will depend on the nature of the evidence which the court has before it. What must be borne in mind, however, is that the conclusion which is reached, whether it be to convict or to acquit, must account for all the evidence. Some of the evidence might be found to be false, some of it might be found to be unreliable, and some of it might be found to be only possibly false or unreliable, but none of it may simply be ignored. So it's a holistic approach that's adopted, Your Worship. Thereafter, in State v. Van Aswegen in 2001 in the Supreme Court of Appeal, Justice Cameron followed this approach and held that a court did not base its decision that to convict or acquit on only a portion of the evidence. The decision had to take into account all the evidence. And then in State v. Chabalala, which is a 2003 Supreme Court of Appeal decision where Justice Hare held the following and said, the trial court's approach to the case was, however holistic, and in this it was undoubtedly right, State v. Van Aswegen. The correct approach is to weigh up all the elements which point towards the guilt of the accused against all those which are indicative of his innocence, taking proper account of inherent strengths and weaknesses, probabilities and improbabilities on both sides, and having done so, to decide whether the balance weighs so heavily in favour of the state as to exclude any reasonable doubt about the accused's guilt. The result may prove that once a scrap of evidence or one defect in the case for either party, such as the failure to call a material witness concerning an identity parade, was decisive, but that can only be an ex post facto determination, and a trial court and counsel should avoid the temptation to latch onto one apparently obvious aspect without assessing it in the context of the full picture presented in evidence. Once that approach is applied to the evidence in the present matter, the solution becomes clear. In State v. Traynor, another Supreme Court of Appeal decision that was delivered by Justice Nafsa, he held that a conspectus of all the evidence is required. Evidence that is reliable should be weighed alongside such evidence as may be found to be false. Independently verifiable evidence, if any, should be weighed to see if it supports any of the evidence tendered. In considering whether evidence is reliable, the quality of that evidence must of necessity be evaluated as must corroborative evidence, if any. Evidence, of course, must be evaluated against the onus on any particular issue. In respect of the case in its entirety, the compartmentalized and fragmented approach of the magistrate is illogical and wrong. In dealing with the requirement when assessing a claim of private defense that there must be a reasonable connection between an attack and a defensive act, Statement in Criminal Law 4th edition states the following at 107. It is not feasible to formulate the nature of the relationship that must exist between the attack and the defense in precise abstract terms. Whether this requirement for private defense has been complied with is in practice more a question of fact than of law. At 109, the learned author states it is submitted that the furthest one is entitled to generalize as to require that there should be a reasonable relationship between the attack and the defensive act, in the light of the particular circumstance in which the event took place. In order to decide whether there was such a reasonable relationship between attack and defense, the relative strength of the party, their sex and age, the means they have at their disposal, the nature of the threat, the value of the interest threatened, and the persistence of the attack are all factors, among others, which must be taken into consideration. One must consider the possible means or methods which the defending party had at her disposal at the crucial moment. If she could have averted the attack by resorting to conduct which was actually less harmful than that actually employed by her, and if she inflicted injury or harm to the attack which was unnecessary to overcome the threat, the conduct does not comply with this requirement for private defense. In State v. Shackle, Justice Brunt in 2001 also in the SCA held as follows. It is strike principle that in criminal proceedings the prosecution must prove its case beyond reasonable doubt, and that a mere preponderance of probabilities is not enough. Equally trite is the observation that in view of the standard of proof in a criminal case, the court does not have to be convinced that every detail of an accused version is true. The accused version is reasonably possibly true in substance. The court must decide the matter on the acceptance of that version. Of course, it is permissible to test the accused version against the inherent probabilities, but it cannot be rejected merely because it is improbable. It can only be rejected on the basis of inherent probabilities if it can be said to be so improbable that it cannot reasonably possibly be true. Then in Tutor versus the State, the Constitutional Court decision by Justice Unterhalter, in the majority decision he held, on this reading of the extempore judgment, the trial judge made a conspicuous error of law. On a charge of murder, putative private defense is not determined on the basis of a test that is objective. Following de Oliveira, the authorities are clear. The central issue at the trial of the applicant should have been whether the state had proved beyond reasonable doubt that the applicant subjectively had the intent to commit murder. If it was reasonably possibly true that the applicant entertained the honest but mistaken belief that his life was threatened, that was entitled to act in private defense, then the state would not have proved its case. The reasonableness or otherwise of the applicant's belief is not relevant to this inquiry. It is relevant to the question as to whether the applicant was guilty of culpable homicide. The trial judge's invocation of an objective test for putative private defense was an error of law, one that is fundamental to the soundness of his findings as to the guilt of the applicant on the charges of murder and attempted murder. What this illustrates is that the trial judge did not have the applicant's state of mind at the forefront of his assessment. Rather, his assessment of the applicant's defense was marked by what he reasoned to be objective considerations and probabilities. This is the very ambiguity that lies at the heart of the trial judge's formulation of the test for putative private defense. The state of mind of the accused is to be judged. The trial judge stated on the basis of what the accused had in mind objectively considered, and hence on the basis of reasonableness. That is not the correct test, but it appears to have been an operative test used by the trial judge. This too then supports the interpretation of the test for putative private defense enunciated by the trial judge, the extempore judgment, as being a test that references objective considerations. And we say more recently, in the case of Michael Yankees versus the state, which was also a Supreme Court of Appeal decision, Matujani held as follows. The High Court materially misdirected itself by not taking into account the entirety of the evidence and neglecting the fundamental principle in criminal proceedings that the state must prove its case beyond a reasonable doubt. The High Court failed to recognize that the accused is not obligated to prove the truth of any explanation he provides. Rather, the burden lies with the state. If there is a reasonable possibility that the accused's evidence might be true, the accused should be acquitted. The High Court also neglected to evaluate the appellant's countervailing evidence that the complainant had a motive to falsely accuse him of the alleged rapes. The appellant highlighted the social media campaign initiated by the complainant following his refusal to return the stolen money. Importantly, the High Court misdirected itself in overlooking significant email correspondence, text messages, and newspaper articles that portrayed the complainant's unwavering love for the appellant and a sense of betrayal after the appellant defrauded her and absconded with her money. This evidence could redound to the appellant's favor. Furthermore, the court failed to address the inconsistencies in the complainant's testimony, did not provide reasons for giving preference to her evidence over that of the appellant. The court is enjoined to consider the evidence in its totality. At issue in the appeal before us is whether the state has proved the appellant's guilt beyond reasonable doubt. On the evidence presented before the trial court, there is conflicting evidence as to whether the appellant was with the complainant at the hotel when the incident occurred. The state's case is wholly dependent upon the testimony of the complainant. Section 208 of the Criminal Procedure Act provides that an accused may be convicted of any offence on the evidence of a single competent witness. When assessing the credibility of a single witness, it is crucial to understand that there is no one-size-fits-all approach. The evidence presented by such a witness must undergo the same rigorous scrutiny as any other evidence. The trial court is tasked with meticulously evaluating the evidence, taking into account both of its strong points and shortcomings. After this thorough examination, the court must then determine whether, despite potential flaws or inconsistencies in the testimony, it is convinced of the truthfulness of the witness's account. This careful and balanced evaluation is fundamental to ensuring a fair and just legal process. The court must assess the credibility and reliability of the complainant's evidence in light of all other evidence presented. It must weigh the potential risks associated with relying exclusively on the complainant's account as a single witness and seek corroborative evidence from other sources when available. In this instance, no supporting evidence from other sources was available to validate any aspect of the complainant's evidence. Then what I did here, Your Worship, is I applied these principles to the facts of this case. So taking the legal principle of relating to the onus and applying it to the facts of this matter, paragraph 62, I say there is no evidence of the authenticity of the viral video footage or the identity of what appears to be a firearm that is alleged to have been fired by accused one on which a reasonable court acting carefully might convict. 63. The spent cartridge cannot be tied back to the place where accused one was on the stage at the celebration. 64. The suspected firearm cannot be linked to accused one. 65. The spent cartridge cannot be linked to accused one. 66. Nobody reacted in fear in response to accused one's conduct on the stage, in the stadium, during the celebration. 67. None of the 5 South African Police Service members on the stage in the stadium during the celebration saw anything untoward on the part of accused one on the stage in the stadium during the celebration. 68. There is no indication of any physical damage caused by any live rounds having been fired by accused one on the stage in the stadium during the celebration. 69. There is no proof that the spent cartridge that was found on 30 July 2018 was actually fired at the stadium on 28 July 2018. And then in the conclusion, in paragraph 70, I say, due regard being had to all of the above detailed submissions, it is finally respectfully submitted that the accused one ought to be acquitted. And Your Worship, to contextualize that submission, we ask Your Worship to take into account that this was it was an enormous celebration with thousands of people being present, and there's not one eyewitness that has appeared before Your Worship either as a complainant to say that they feared that there was any risk, or more importantly, Your Worship, that they witnessed accused number one firing a live round from a proper firearm. Not one person of those many thousands that were there, and therefore we say that fact in itself, Your Worship, should militate against any possibility of a conviction, and that the accused ought to be acquitted of all the charges. I have no further address, Your Worship, unless Your Worship wishes to hear me on any particular aspect.
Thank you, Advocate Hodes. I just want to find the appropriate page. If one aspect that I would just like to hear your view on, I marked it. Sorry, I'm just looking for the relevant page. Here we go. I'll find the exact page. It is just regarding the submission by yourself with regards to the court recalling Colonel Mgwadleka. I think that aspect was put to rest, and on the 30th of January 2024, when the court made available the recording to the state, yourself, and Advocate Matthews, we returned to court, and it was then agreed on he was excused or for follow-up questions by court's questions, but not recalled in the sense of being recalled. And I just want to clarify or rectify that submission.
Paragraph 4.9 of my heads of law.
Yes, exactly.
And I know from preparing for here that the brackets don't close, Your Worship. But I said, and I made it very clear, Your Worship, because I'm in respectful agreement with Your Worship. Your Worship said, I've put here from line 3, you'll see where the brackets begin. We're subsequently called by the magistrate to clarify certain aspects of his testimony. And then I say which resulted in him effectively testifying twice. But the point is, Your Worship, that it was to clarify aspects, and Your Worship had reserved the right to do so, and that's why Your Worship refused to recuse yourself, and I abide by and respect that decision, Your Worship. I've taken issue with that for obvious reasons.
Thank you. That was the only aspect I wanted to clarify.
No difficulty as an officer of the court clarifying that Your Worship had said that witness may be called by the court to clarify the later stage. That's precisely what then did happen, Your Worship. Thank you.
Advocate Matthews.
Thank you, Your Worship. I'm in a good position because I've listened to Mr. Caesar expertly put the state's case to you, and I've listened to Mr. forgetting his name now, on behalf of on behalf of the accused number one, was more than expertly put not only the case in question, but also all the legal principles applicable to this matter. Your Worship, I want to commence with the case for accused number 2 by emphasizing the fact that accused number 2 is charged on 2 counts, in counts 4 and 6. If we look at count 4, is an alleged contravention of section 120 sub 3c, where it is alleged that on the 28th of July the accused had control of a loaded firearm, to wit a Norinco .223 rifle, in circumstances where it created a risk to the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, and unlawfully failed to take reasonable precautions to avoid the danger. Now, unless I've been sleeping, which is possible, I've heard no evidence whatsoever that can substantiate this particular count. The state itself has conceded in its heads of argument that it cannot substantiate a conviction on the fact that accused number 2 handed over a firearm to accused number 1. Added to that, there is absolutely no evidence at all that he was in possession of a loaded firearm, a Norinco .223 rifle, in circumstances where it created a risk to the safety or property of the general public. A learned colleague for accused number 1 has addressed you on what happened on the evening in question. I think we need to just step back and look at this objectively from afar. We are here to assist Your Worship in arriving at a proper decision in this matter. The Economic Freedom Fighters is a registered political party in South Africa. It had a right to engage in the celebrations as it did on the evening in question. I think we need to understand that it simply did not rock up at the stadium, pitch up a tent, and start a shindig. A joint operation command had been established prior to this, which encompassed numerous police divisions and obviously even paramedics. There were 20 to 30,000 at least people present on the scene who had come for the celebration. And as we have seen, there were quite a few prominent people who were present even on the stage on the evening in question. Long after the chants of KGB had disappeared into the night and the dust had settled, not one person came forward to lay a complaint about what had happened on the evening in question. Instead, the police picked up a video on social media which allegedly depicted accused number 1 firing what they claimed is a firearm into the air. And from on there on, an investigation ensued. In fact, the police themselves are the complainant in this case. Why I emphasize that is looking at count 4, where it is alleged that, firstly, that accused number 2 was in possession of a loaded firearm, this Norinco, in circumstances where it created a risk to the safety or property of the general public. Nobody has come forward to testify about this. and the state's concession that it cannot justify a conviction on the basis that accused number 2 handed any firearm at all to accused number 1 is well-founded. I do not think it is necessary for me to go into this any further, because I honestly believe that the court is not in a position, the state is not in a position to request a conviction on this count. Count 6. Contravention of section 120(10) of the Firearms Act alleges that the accused did unlawfully supply or in any other manner give possession of a firearm, to wit a .223 Noringa rifle and a Remington bullet, to Julius Malema, being a person who is not allowed in terms of the Act to possess that firearm or ammunition. Now, again, the state has conceded that there is insufficient evidence to justify a conclusion, especially beyond all reasonable doubt, that accused number 2 in fact handed a firearm to accused number 1. In fact, the state is now arguing the opposite. It says that, looking at the viral video, which I will return to, it is clear that he was as surprised as everybody else by what happened on the stage, be that as it may. It is clear then, Your Worship, that with the greatest of respect, one would have difficulty in justifying a conviction on this count. Because this is such a wide definition, and Your Worship is quite correct in the section 174 in a sense that the definition of this particular offence does not only mean that you physically handed over the firearm to another person, it could be that you supplied in any other manner the firearm to him. That is why, Your Worship, long before this case was even contemplated, the state was requested to indicate on what basis it is alleging the accused contravened this particular section. It is not within my nature to apply for further particulars, but it is necessary in this case, I think one can see it, that we need to know exactly why you're saying he contravened this section. The state replied that he had physically handed the firearm to Mr. Malema. And my learned friend clearly, to give him credit, has justified that he cannot support a conviction based on this. Based on Your Worship's judgment in the section 174, if I may just get to this point, because my learned colleague in his heads of argument and argument before court has indicated a puzzlement, if I may call it that, as to why Mr. Martin Hood was called to testify. Now, in any other manner, give or supply, as Your Worship pointed out in the section 174, we were taking a too narrow interpretation of the physical handing over of the firearm. That was because Your Worship was not in possession of the further particulars at the time. Mr. Wood testified that he, as an attorney, was intricately involved in tactical security services. He was the person who did all the firearm applications. He testified that Mr. Clement Ndluli was the responsible person for the company, and that this firearm was, in fact, booked out to one Larry Mavundla. It had nothing to do with accused number 2. That evidence was never disputed by the state, and I think it is the truth, so why dispute it in the first place? That brings me to one criticism which I need to raise, and that is Larry Mavundla. Your Worship, if anybody could have answered in this particular case as to why a firearm which is allegedly linked to a cartridge case found at this particular stadium, if anybody could have answered to that, it would have been Mr. Larry Mavundla. Now, I don't think my learned friend meant it in the sense as he said it when he was cross-examining accused number 1. But it appeared to us that he was saying that this evidence of Larry Mavunda has now only arisen after accused number 1 started to testify, which is obviously not the truth. Because if you look at the further particulars, the state in its further particulars alleged and stated that Larry Mavunda was the person to whom the firearm was booked out. He was present in East London on the night in question. He was present at the stadium on the night in question. And as accused number 1 has testified, he was on the stage, standing right next to him. The difficulty I have with this is I'm failing to understand why the state did not engage Mr. Larry Mavunda. We know, Your Worship, that if a witness doesn't want to cooperate with the police, it's a very simple procedure to Section 205 in, which means you are served with a subpoena to appear before a magistrate and tell the magistrate what you know about the case. If you don't do so, the magistrate will sentence you to prison. It's a simple procedure such as that. I think the reason why the state didn't engage Mr. Larry Mavunda is because they were aware that Mr. Mavunda, on the day when he came to Durban with his firearm and met with Colonel Janssen, told Colonel Janssen that this firearm, I believe you're looking for this firearm, you want to test it for what happened in East London, but this firearm was not in East London on the evening in question. Now, Colonel Janssen was at TSS to do a security check on all the firearms. He was in fact a very good witness when he testified. I don't think any of us challenged what he was saying. And it is clear from this particular piece of evidence, and if we're going to take it into account, we must take the whole piece of evidence into account. Don't stop at the point where Larry Mavunda says, I brought the firearm because I believe you're looking for it. Add on. But this firearm was not in East London on the evening in question. It's clear to me, Your Worship, that accused number 2 cannot be convicted of contravening Section 120.10 of the Firearms Act because it is clear that there's simply no evidence on which this court can say beyond a reasonable doubt he handed the firearm to Mr. Malema. If I may just deal with another 2 aspects which, well, let me just say this. We have submitted at the end of the argument. I'm not going to follow my learned colleagues' examples of going through paragraph for paragraph. Your Worship can read what you want to read and discard which you want to discard. I want to deal with this video evidence. We have 2 videos, and dealing with the video evidence, you must understand something, that the state is conceding that accused number 2 cannot be convicted based on the viral video. However, there must be a word of warning about this video. Everybody's talking about the advent of artificial intelligence. It's not a new thing. In order for a court of law to be satisfied beyond a reasonable doubt that a video that has been played to it is sufficiently authenticated and sufficiently true that a court can rely on it, there are certain steps surely that must be taken. In our law, unfortunately, old English law, a distinction is tried to be drawn between what is documentary evidence and what is. It serves no purpose with respect in these modern times to go back to some old English law. What we need is a guideline as to how these videos should be accepted by the court. We know that closed circuit television is a very, very important tool against the fight against crime. We see it of videos of cameras that are set up in intersections that depict accidents that happen. We see it at ATMs where people are stealing money. We see it in firms. In fact, there's hardly a place in the world where you're going today where you're not on camera. It's important, therefore, that before a court can take into account evidence of a video such as this, we must be satisfied as to a number of aspects. And these aspects, strange enough, in State versus Raymond Robert, which is a long time ago, 1986, the judge indicated that in order for cell phone or photos or videos to become relevant, the first step is it must have bearing on the issues to be decided by the court. And I concede that that is in fact so here. Secondly, it should be verified as being a true image of what was captured by the person who took it. Thirdly, it should be clear and not edited. And fourthly, it should be presented to the court to be viewed as has happened here. And fifthly, the device on which the photo or video was captured, should be reliable. Step back again, Josh. What are we looking at here? We're looking at a viral video on social media. I've actually seen a video of your worship dancing on the stage at this EFF. Somebody thinks it's funny to be able to put us all there. We're dancing and kicking and enjoying ourselves. It is so easy for these type of videos to be manufactured and put onto social media. I'm not saying that this one was done like that, but what I'm saying is that before a court of law can rely on something like this, this is not the original video we are seeing. It's a video that's downloaded from social media. Any one of us can look on YouTube now and download it. I'm sure most people have. The video that was sent to the police, on which this case is based, we know, was sent from policeman to policeman's cell phone. Now, is that going to be a satisfactory method of how we're going to deal with these videos? I say not to it. We need the person who took that video, and there can be no difficulty for the state to have traced that particular person. If they posted it on social media, then you are able to trace who posted it. It's no different to somebody making racist remarks on a Greek island on a video. They trace him as to who he is. In this particular matter, they could have traced this person. We don't have to rely on second or third or fourth hand videos in court. The second video was taken by my learned friend for accused number one has dealt with it in depth. It was taken by Gearhouse, who was employed by the EFF to video record the proceedings. Unfortunately, in that matter, the original hard drive is missing. We have heard evidence, however, from somebody from Gearhouse who said he viewed it and he can authenticate it. So I concede that. The first video, however, is the problem. When I say it's a problem, I'm actually arguing against myself because it assists accused number two in the sense that, as the state has indicated, that video shows that he was very surprised by what was happening. Bishop, I need to move on then just to this aspect of being an accessory after the fact. We know from the evidence before court that this charge was never put. These are statutory offences. They do not have competent verdicts. That my learned colleague for the state had at the last minute raised this issue. From your worship's reaction to it, I could see that you're not really interested in it. However, let's for the moment leave aside the legal argument and look at the factual aspect of the case. Is there any evidence that accused number two, firstly, changed the bolt on the firearm, or secondly, was involved in picking up cartridge cases, at the stadium in question, because these are the two factors my learned colleague was relying on to base the conviction of being an accessory after the fact. Surely we can simply dismiss it because we know, having listened to all the evidence, that there is no such evidence that this in fact happened. Frustrating part of this case for me has been the evidence presented on the ballistic side of this particular matter. When the gun fires a cartridge, it imprints certain marks onto the cartridge case. From the firing pin, the breech face, the extractor, the ejector, the chamber marks. We know that it's established that this is in fact what happens when a cartridge case is fired. I've yet to find a case in South African law which sets out what are the requirements for a court before it can rely on a ballistic match in a particular cartridge, dealing with cartridge cases. We know overseas in law, Dorbert in the United States, many other cases, all differ in a sense that various jurisdictions require various standards that must be applied. Ballistics is not a science. It is an objective opinion of somebody looking through a comparison microscope at what he perceives to be a match of a cartridge case. You look at DNA, for example. We know now that none of our DNA is the same unless you've got a twin. If we look at our fingerprints, we know that none of our fingerprints are the same. We know that there are certain standards that are required with a fingerprint, 7 marks. We know with DNA, we eventually get you could be a 1 in trillion person. Look at ballistics, nothing. I'm concerned in this particular matter, this cartridge case that was allegedly found on the scene. The state has indicated in its evidence that we found neck marks on 2 different places of the neck, which in comparison to tests fired out of this firearm, he comes to the conclusion that they are similar. What we know for certain is that the firing pin, the breech block, the extractor, the ejector are all negative. Now the explanation given for that is, well, the bolt of the firearm must have been changed. Look at no evidence that any bolt of any firearm was changed. And just to correct my learned friend, of these particular firearms and the maker firearms, there are 3 which have no numbers stamped on their bolts. It is not a requirement of this particular firearm that it should have a number stamped on the bolt. In fact, there are 3 of these firearms that don't have any numbers stamped on the bolt. It is not like the serial number stamped on every moving part of the firearm like we get with other firearms. The conclusion the court would have to draw from this is that the evidence of the so-called match of this cartridge case is of such a strong evidence that all the other negative parts of the firearm, in other words, the extractor, the ejector, the firing pin, you can ignore that. The manner in which the state presented this evidence is also of concern to me. A court of law is not there to simply accept what an expert says. The expert can't usurp the function of the court. There needs to be an explanation as to how you came to your conclusion. You can't simply hand up court charts. You've got to take those court charts and explain how you came to that conclusion so that the court can be satisfied that the manner in which you came to the conclusion is satisfactory to find beyond a reasonable doubt that that firearm fired that particular cartridge case. We know that the cartridge case was found I see, and I mean no criticism, but in your 174 judgment, Your Worship has indicated the cartridge case was found close to the point where it was fired. It was not found close to the point where it was fired. It was found in a tent some distance away. We know that that cartridge case could not have got there through the firing of the firearm. It is too far away. The firearm ejects, we've got all these tests that were done by it. The firearm ejects a certain distance. We don't know how it got there. It could have been kicked there, it could have been landed there, it could have, when the people were cleaning up afterwards, it could have flapped with the tent and gone there. We've got no idea. The point I'm trying to make is that we've got a bit of a quantum leap here. We found a cartridge case and then we say it was fired by this firearm and then we say it was fired on that evening out of that particular firearm. In the absence of the man whose firearm it is, who's there on the state, who the state could have called to come and testify or forced him in terms of Section 205, I don't think much reliance can be placed on this particular matter. It supports accused number one's version that the firearm he was using on the evening in question was not a real firearm. Your Worship, there are other aspects of the heads of argument I've dealt with that I don't want to emphasize at this particular stage unless there's something, and I'm sure there might be something you want me to talk about. I've dealt with the Baksa's case. The Baksa simply says at paragraph 10 on my heads of argument that a failure to discharge an accused at the end of the state's case can be a misdirection, because if he was alleged, should have been discharged at the end of the state's case and you don't, that might be unconstitutional. My learned friend has conceded at the end of everybody's case that he does not have a case against accused number 2 of handing a firearm over to accused number 1. He should probably have done that at the discharge stage. Unless there's something else that you want me to deal with, my submission is very simple. Reading the count 4 and count 6 and the requirements of those two sections before you can convict accused number 2, my submission is very simple, is that there's insufficient evidence to find him guilty in this case. Thank you. I'll remain standing unless you have any questions.
I have none. Thank you, Matthew. Advocate Caesar, is there any reply by the state?
Thank you, Your Worship. I'll start with my colleague's last point regarding the listing evidence that is on particular sites. You should just remember that what Leka's expertise is as far as firearms are concerned is there to assist the court to come to a particular decision as to pass. A particular field that the court might not have so much knowledge about. his evidence was clear in this regard that that particular spent cartridge case that was found 2 days after the incident was indeed linked to the SPA 249, which belonged to the company that accused number 2 is working for, is employed. I did undertake to inform last time that I will refer the court to the particular page number in Guadaleka's evidence where he actually testified that 4 cartridge cases that was test cartridge cases tested positive for the spent cartridge case. It's on my apologies, on page 44 of his evidence. In the record, the transcribed record. Page 44, lines 18, line 17 to lines 19. They confirmed that he tested that 4 of those tests spent cartridges, not one has been alleged. It was 4 tests that tested positively to that spent cartridge case. There was also an issue that whether he testified, whether any peer reviews was done. If you look at the transcribed record, Guadaleka confirmed that on page 37, lines 12. There's also other pages where in cross-examination where he was requested or tested on that, where he actually confirmed again that there was indeed peer reviews done in respect of the test that he performed. Guadaleka's evidence further insofar as the spent cartridge case are concerned, he testified that indeed on page 23, line 16 to line 20, he confirmed that the bridge block, also being referred as the ball carrier, was indeed changed of SP2 to affect the results and the outcome of this particular. On page 61, under cross-examination, lines 10 to 15, Guadaleka again confirms that these parts have been indeed changed. The ball carrier, which consists of the firing pin and all these aspects that was already been mentioned by counsel for accused number 2. The ejector, the extractor, and so on. That he confirms that indeed it has been changed. That's why he had to go to the actual chamber. The chamber is where the neck of the firearm and the barrel is actually. It's very difficult to change. That's the one thing in the firearm that you actually need a gunsmith to change that particular part of the firearm. You should be further testified of all the number of firearms that he examined for the ballistic test which he received from the company of accused number 2. That was indeed the only firearm with ball carrier. Has been changed. Not 3 has been mentioned, but that was the only one of the ones that he has tested or that was sent to the lab. The issue, I want to address the issue as far as the viral video is concerned. We have argued this matter meticulously before the video footage was deemed to be admissible. The only issue that the court needed to consider is whether it was indeed a relevant not whether it's authentic or any case law is clear in that regard. It needed to be relevant. That was already conceded. The other points that was mentioned by counsel for accused number 2, I am in disagreement with that. Court only need to consider, and the court's got to safeguard all the evidence of House insofar as confirming the video footage. I take note of counsel's for accused number 2 argument about the AI and so on. This is not the case in respect of this particular video. As a matter of fact, it's not the content from what I could see, not the content, it's the actual video footage that has actually been disputed. Because they've relied, as I've already previously pointed out, they've relied on the exact video footages from both sides. Not saying, no, there's something wrong, this has been edited here and edited there. There was no such admissions made. And to make it at this point, it's rather pointless. This is the evidence that has been presented before this court is real. The issue regarding Larry Mabuntla that was raised, that we should have sent out a subpoena to a witness that appeared clearly hostile and not wanting to assist the state, was just disingenuous. It would have amounted a waste of state resources. On this point of Mr. Mabunta, it is accused number 1's evidence that this firearm that was given to him, the toy one, that's as he's alleging, was indeed given by this particular Larry Mabunta, whom we know the firearm was booked out to on the night in question. The issue is that the distance where the spent cartridge was found in relation where the stage was, is neither here or there. Our submission there is whether it was found on the roof or 15, 20 meters from the incident. Remember, these evidence, the stage was reconstructed in the evidence of Becker. So it wasn't an exact science that exactly that is where the stage, but the fact that it was found in such close proximity where the stage was erected originally, this is clear that that firearm was discharged on that night in question. If the court had looked at the timeline, the incident happened at late the Saturday evening, the 28th of July, 2018. We know from the evidence that on the Sunday, which is the 29th, there was no real activity other than yells dismantling the stage. The following day, that was the Monday when the cleaners came out, that is when the spent cartridge case was found. the evidence of accused number 1 in this regard is nobody else had fired shots on the night in question other than himself. So on that basis, the state is submitting that its case had been proved beyond reasonable doubt. The court was presented with real evidence. Insofar as the video footage is concerned, the evidence relating to, I've already submitted that this is the best evidence the court would have ever gotten as to what had really transpired on the 28th of July 20. No witness would have been able to describe the incident, the clothing, the singing, the chanting, who stood where accused number 1 was in relation to when he fired the shots. I've already submitted that is the best silent witness, the best evidence any court would ask for when it comes to video footage technology. There was also a submission made that nobody ran or nobody seemed to. It was clear from that video footage, the moment accused number 1 fired that shot, the first round of shots, people were running. We counted at least 7 people that were running because accused number 1 went to the end of that stage to fire those shots in the direction where those 7 people were standing. As a result, they were running. So to submit that nobody did anything at that, it's incorrect. Yes, I've already submitted that we have gone through the evidence. If accused number 1 was innocent in any way, I would have made that submission, like I did in respect of accused number 2. The evidence was viewed by 2 different prosecutors, as your worship is aware, Advocate Smith as well as myself, and we both came to the same conclusion insofar as the evidence is concerned, and we both have more than 50 years of experience. My job is not to get a conviction at all costs, but to assist the court to come to the correct decision. In this regard, it is clear that accused number 1 did indeed fire those shots with SPA 2409, and that he should be convicted of the charges as it stands. Thank you.
Thank you. I know you are eager to reply, although there's no provision for that, Advocate Odes and Advocate Matthews, but I will indulge if you so wish, but you say nothing. I see Advocate Odes. I will give you the opportunity, although it's not part of procedure.
I appreciate the indulgence, Your Worship. I take issue with almost everything that my learned friend has said for the state. And I urge Your Worship not to be convinced by the manner in which he argues, excuse the pun, with conviction and in the eloquent manner that he put it forward. And I'll make my points very briefly, Your Worship. And he said to Your Worship, the only firearm of accused 2 for which the barred carrier was charged, there isn't any evidence, Your Worship, that accused 2 has any firearms before this honourable court, sir, or even that firearm can be connected to accused 2, and that was the evidence that was undisputed before this honourable court. Your Worship, I also take issue with him saying that the only test in relation to videos, whether it's relevant and not authentic, that goes against the Rangovan decision, and to a large extent merely arguing the case for accused 2 as put forth by Mr. Matthews, but I feel compelled to do so because I'm just answering to this. Then the other issue, Your Worship, was he said that if one has regard to the fact that we say that that the state should have called Larry Mavundla, but he was clearly hostile. He's giving evidence. There's no such testimony. In fact, Your Worship, I wanted to give Your Worship the reference, if I may. The captain's statement, Your Worship, is an exhibit before this Honourable Court. It's Exhibit C. It's also referred to, Your Worship, at our paragraph 4.7 of our heads of argument. And at Exhibit C, I beg your pardon, it's Colonel Janssen, not Captain, Colonel Janssen. In his statement at paragraphs 9 and 10 said that Larry Mavundla was fully cooperative. So I don't know on what basis he wants this court to accept that Mr. Mavundla, who was identified as being on the scene and who was alleged to have owned the firearm, was hostile. Because if one has regard, Your Worship, to Exhibit C, and I'll quote it to Your Worship, it's quite clear with respect that Mr. Mavundla was cooperative as per the statement of the very Colonel Janssen, paragraphs 9 and 10. He says there, on the same day after inspecting the main safe, firearm number 6 was presented for inspection, as well as a 9mm P Glock pistol with serial number YYS58 by Mr. Larry Mavundla. The explanation was that the company knew that SFS were needed for ballistic testing as a result of the alleged discharge of a rifle by Mr. Julius Malema over the weekend of 28 July 2018. And then in 10 he says, the explanation given was, although the firearm was not in East London, on 2018-07-28, the responsible person volunteered this firearm as well as all other firearms in their possession for ballistic testing. So I don't know how one can infer from that that this was a obstinate or difficult witness or uncooperative. In fact, the opposite appears, because he seems to have assisted. Then my learned friend also argued, and now thankfully we're turning closer to accused number 1's case, that it made no difference where the cartridge was found. You only have to ask yourself, Your Worship, as in the tests enunciated in the case that I quoted, the corollary of that. Had the cartridge been found 1.2 meters to the right of where accused number 1 was standing, to his rear, then the state would say, look how it fits in with the trajectory and how easily it ties in. So I absolutely disagree with him, Your Worship. And then he says that according to the witness Becker, the stage was reconstructed. It was quite clear it was never reconstructed, Your Worship. I don't know where he came with that evidence. With respect, Your Worship, that's why I say that one cannot, with respect, accept that. And then he said that the accused number 1 admitted that on the night in question that he was the only one that had fired shots. But that doesn't answer the question, Your Worship, because there's no proof that the cartridge arose on that very night. So it could have been there before, it could have come there after. There isn't even proof that cartridge was shot. So it could have got there at any time or even been dropped there. There's nothing that ties in with that one fact. And that's why I ask Your Worship to have regard to the cases that we referred to which say that you must take cognizance of all the evidence, not just aspects that suit the state's case. Similarly, Your Worship, and this is the clearest example of my learned friends arguing with conviction, with eloquence, but not fitting into the facts, where he says that if number 1 was innocent, he would have made that submission like he did with accused 2. What did he do, Your Worship? He charged accused 2. When the evidence didn't substantiate it, he then changed his tack and said, well, find him guilty as an accessory after the fact. That's not saying the man's innocent, let him go. And not once did he say that, Your Worship, and that's why I take issue with that statement, and I say that that's totally irrelevant, and it's not even a factor, because it's not the case, it's not borne out by submissions and arguments. Thank you, Your Worship.
All right. I'm happy to say we've reached the conclusion of everything, and now the ball will be in my court, and I'll have the opportunity to speak, but not today. So do we arrange a date in chambers? What do you prefer?
Let's adjourn, let's adjourn and arrange a date each year.
Your Worship, we had set down 3 days. I know it's not attributable to Your Worship, so I'll take no issue, but I have my diary here, perhaps we can even arrange here, Your Worship. I have no difficulty. I have my diary here and can arrange a date in open court, Your Worship, rather than arranging, but I'm in Your Worship's hands.
I don't know whether there's any possibility that we could probably stand down till Wednesday with that.
That's never going to happen, Advocate Matthews. I think yourself, Advocate Odes, Advocate Caesar, you know the amount of work you've put in, the hours, the days, the months. It cannot be done in one day. This court is in session 5 days a week in excess of 5 to 6 court hours daily, with a turnaround judgment time of every day due. My after-hour times are limited. They are exhausted, including weekends, public holidays. They are fully booked. But once we've reached this point, of course, it becomes due, and I have to spend those hours and days and weekends preparing for this.
You cannot suggest a date, 26th
26?
of January.
Can't require so many months. No. Now that it's due, you put in the work, but it cannot be done in one day. I think you can appreciate that fact. I hear that you would love it to be finalized, but I also need to address many aspects that have been placed on record.
Sorry, we're talking about the 26th of January next year.
Is it not so?
Sorry, I thought you said January next year. No. All right, the only other time we'd open is from the 18th of August to the 22nd. Otherwise, then we are really going into next. I'm the first one to praise regional court magistrates who were sitting with 4 or 5, 6 sometimes murder cases on their roll in a day, where the High Court has probably got 2 for a session.
I've got 187 cases to deal with.
Exactly. So I really do understand you. Please don't misunderstand. But you must understand that those 186 cases must also be serviced by us. So our time is also taken up.
Of course.
So I'm suggesting from the 18th of August. I don't know when I'm identified, so I'm ready for it.
Okay. Look, what I'm going to do at this point, since we've encroached on everyone's time and possibly your clients need a water break or a bathroom break, you can discuss dates. You don't have to discuss it with me in chambers. I will come back to court and you can give me the proposed dates and I can cross-reference in my diary as well. Okay. So can we just agree on what time you would like me to be back?
Put it to 12.
You say it's so convenient. And if I say to you, Advocate Matthews, it's 11:45 now?
It's all fine.
I see you've got your phone. Okay. I've moved offices, so it will take me between 11:45 and 10 to 12. I'll be back in court. Thank you. Court will adjourn. Thank you.
Okay. Ungenzela i-favor, ngicela ngi-check-ele ukuthi ayizwa yini i-audio kaMalema because efonini yami ngithi ngiya-check-a ngiyizwa but ngiyivulile i-audio la endlini. Okay. Hello? Is it fine? Yeah. Or if it. Okay, so you
I can't see Shamias.
okay.
What is that down there? Oh God! Shh. Don't speak, baby. Don't speak. Don't speak at all. Don't speak at all. The mic that is at the bottom, close it.
The 29th of September, both on bail, warned 8:30, Regional Court 4, for judgment to proceed. Thank you. Court will adjourn. Thank you.